The Compliance Perspectives podcast is sponsored by Case IQ, a global provider of whistleblowing case management and compliance solutions. Learn more at caseiq.com. Welcome to the Compliance Perspectives podcast. I'm Adam Turteltaub from the Society of Corporate Compliance and Ethics and Healthcare Compliance Association. Joining us today from Washington, D.C. is Josh Drew. Josh is a member at Miller & Chevalier. And today we're going to be talking about developments in the False Claims Act. There's been a lot going on with a very old piece of legislation and how it's being implemented or enforced. And Josh is here to take us through that. Josh, thanks for joining us. First, most people on the call are familiar with it. Some may not be. So can you just give us a brief overview of what the False Claims Act is and how it works?
Sure, Adam. Happy to do that. And nice to be with you on the podcast again. So as you mentioned, the False Claims Act is an old statute. It's been with us since the Civil War era. And it allows for cases to be brought based on false statements to the government and for money damages to be recovered. So a statement that is false and made with the requisite knowledge and material to a government decision to pay creates liability under the False Claims Act if made to the government and relied upon. The statute provides for treble damages, meaning 3 times the government's harm, the amount they overpaid, as well as civil penalties and collateral consequences. And it has a provision that allows private individuals, who are called relators, to file suit on behalf of the government. And those relators can receive between 15 and 30% of any recovery in the case, depending on the circumstances. So it's a very powerful statute.
Yeah, it's very, and we've seen a lot of action in whistleblowing, but also in general, what's going on there and a lot of changes. Now, there's some very notable recent initiatives related to the False Claims Act that I'm hoping you can walk us through. First, can you talk about what happened with the Civil Rights Fraud Initiative?
Sure. That was an announcement by the current administration in May that essentially proposes to use the False Claims Act against any federal funding recipient that operates diversity, equity, and inclusion programs in violation of the antidiscrimination laws. And while that's a broad mandate, the initiative, when it was launched, specifically mentioned targeting institutions of higher education.
And secondly, in July, there was a False Claims Act working group established. What was its sort of area of focus?
Yeah, that was another notable development in this space. It's a joint effort between the Department of Justice and the Department of Health and Human Services, focused on the healthcare life sciences space, which historically has been very active for False Claims Act matters. The task force encouraged whistleblowers to report False Claims Act violations in a number of key enforcement areas, including Medicare Advantage, which is also known as Medicare Part C, drug, device, and biologics pricing, anything related to barriers to patient access to care, kickbacks, defective medical devices, and manipulation of electronic health records. So a serious effort to scale up False Claims Act actions in the healthcare and life sciences space through that task force.
And this, of course, all these changes go beyond healthcare. In August, there was also a trade fraud task force. What is its area?
That was announced just a couple of weeks ago, Adam, and it's a deployment of resources from the Justice Department's civil and criminal divisions, as well as the Department of Homeland Security, with the stated purpose of aggressively pursuing enforcement actions against tariff violators, smugglers and importers, including through the use of the False Claims Act. And again, the task force is encouraging whistleblowers to come forward with information to help build cases. And I would say all these initiatives are against the backdrop of earlier announcements by the administration that state priorities for enforcement, including the executive order in January regarding, quote, ending illegal discrimination and restoring merit-based opportunity, which specifically mentioned higher education institutions with endowments over $1 billion, and a white-collar crime priority memo from the Justice Department's Criminal Division in May, outlining specific areas of focus, including waste, fraud, and abuse, with a specific call out for healthcare fraud and federal program and procurement fraud, as well as trade and customs fraud, including tariff evasion. So there's a fairly concerted effort across the piece when it comes to the False Claims Act.
So, as these efforts are all happening, what sectors, industries, or activities appear to be in focus? You mentioned higher ed, healthcare. What else and who else should be concerned?
Certainly those two. And as I mentioned, healthcare has been historically extremely active, fertile territory for building False Claims Act cases because of the amount of money in the federal budget devoted to providing healthcare insurance through Medicare, Medicaid, other government payers. Higher education has been really in the hot seat in the last 6 months and more. Much of it, the activity surrounds DEI initiatives and evaluation of those programs, import-export firms, and also national security sector. There have been a number of recent enforcement actions in that area.
So, what are some of the key risk areas? You've touched on it a bit, but I'm hoping you might be able to drill down a little bit more for us.
Sure. As I mentioned, organizations that receive federal funds should review their DEI related programming, as DOJ is targeting that activity and evaluating it for consistency with federal civil rights laws. In the higher education space, grant applicants need to take care, as their applications and certifications can form the basis for funding decisions. And so breaching those conditions can be a basis for exposure. Another area to think about is cybersecurity. Vendors providing IT or cybersecurity services to the federal government have been the subject of several recent FCA settlements. There have been at least 3 that I know of in the last few months. And just more broadly, any entity participating directly or indirectly in federal procurement needs to be aware of the aggressive False Claims Act initiatives that we've been discussing. I think ultimately understanding key risk areas based on the initiatives from the current administration in the last several months will take time to understand more fully. As you know, the gestation period for these cases is months, if not years.
So finally, given everything you've told us so far, how can organizations defend against False Claims Act cases or at least reduce their risk by improving compliance and controls?
Well, the good news, if there is some from these initiatives, is that the tried and true mechanisms, methods, processes for assessing and mitigating risk remain relevant and effective in the False Claims Act context. So, your listeners who are compliance professionals, run ethics and compliance programs, will be familiar with the frameworks, the core elements of policies and procedures, training, education, auditing and monitoring, and the DOJ guidance on compliance programs, evaluation of corporate compliance programs, which was last updated in September of last year, remains relevant. HHS, the Department of Health and Human Services Office of Inspector General, also has guidance, and that remains a touchstone for those operating in the life sciences space. I think if there's one element of an effective program to call out and really focus on when you're thinking about False Claims Act risk, it would be having an effective reporting line, internal investigations, and remediation process, because so many False Claims Act cases arise from whistleblower complaints, and so many whistleblowers first attempt to raise their concerns internally. And it's often when their employer company's internal response is not effective that they seek other avenues to raise their complaints. And some of those cases turn into False Claims Act actions.
And the lawyers who handle them have often said that a lot of times the reason people end up in their office, if not most of the times, is because they tried to get an issue addressed internally and no one did. Well, Josh, thank you so much for sharing these insights into the False Claims Act with us today. I want to thank all of you for taking the time to listen. I'm Adam Turteltaub from SCCE and HCCA. I hope we're able to expand your compliance perspective.